Too many Nigerians are in prison today, not because they're guilty, but because they didn't know the process. Let's break down the Nigerian criminal justice system from report to trial, step by step, with real visuals. Number 1. Report or petition. A criminal case begins when a report is made to the police or relevant law enforcement agency, like EFCC, NDLEA, ICPC, NSCDC. The report may be oral or written, a petition submitted by a lawyer or individual. The police must register the complaint in a crime diary or petition register. Number 2. Preliminary investigation. Police conduct initial fact-finding to verify the complaint. If the report is frivolous or civil in nature, the case may be dropped or redirected, e.g. to a civil court. If the matter is criminal, they proceed. Number 3. Invitation or arrest. Police may first send a formal invitation to the suspect. If the suspect fails to honor it, or if the case is urgent violent, the police may proceed with an arrest, with or without a warrant. Number 4. Arrest. The suspect is informed of the reason for the arrest. Arrest must follow due process under Section 35 of the Constitution and the ACJA 2015. Unlawful detention, torture, or arrest without charge is a violation of human rights. Number 5. Detention and statement. After arrest, the suspect is taken to the police station. The suspect may be held for 24 hours for minor offenses, up to 48 hours for serious offenses, unless a remand order is obtained. The suspect is asked to give a voluntary statement, which must be, in writing, witnessed by a lawyer if desired, signed or thumbprinted by the suspect. Number 6. Investigation. Full investigation begins, gathering evidence, visiting crime scenes, interrogating witnesses and suspects, conducting forensic or medical examinations if needed. Police may search property with a valid warrant. Items like phones, weapons, documents may be seized as evidence. Number 7. Legal advice, DPP stage. For serious crimes like armed robbery, murder, rape, kidnapping, the case file is sent to the Director of Public Prosecution, DPP. The DPP gives legal advice, approve the case for prosecution, ask for further investigation, recommend discharge for lack of evidence. Number 8. Filing of charges charge sheet. If approved, police or DPP prepares a charge sheet for magistrate court or information for high court. Charges must include name of the accused, date and nature of the offense, relevant law violated. Number 9. Arraignment. The accused is brought to court and formally arraigned. The court reads out the charges. The accused enters a plea, guilty or not guilty. Number 10. Bail application. At or after arraignment, the accused may apply for bail. Bail is discretionary depending on nature of offense, risk of flight, interference with investigation or witnesses. Number 11. Trial. Prosecution presents evidence and calls witnesses. The defense cross-examines and presents its own case. Trial follows the rules of evidence and procedure. The burden is on the prosecution to prove guilt beyond reasonable doubt. Number 12. Judgment. After both sides are heard, the court gives a verdict. Conviction if guilty, followed by sentencing. Acquittal if not guilty, suspect is discharged and freed. Number 13. Sentencing. If found guilty, the court issues a sentence based on the law, circumstances of the case, mitigating or aggravating factors. Number 14. Appeal optional. Either party can appeal the judgment to a higher court. Court of Appeal, then Supreme Court.